Hi, it's Roland Jones. This is another video in a series of videos on preference and fraudulent conveyance issues. Today I'm going to focus on defenses to a clawback, a preference clawback in the construction business, primarily contractors or subcontractors, and see what kind of special defenses are available for folks in this industry. First defense that's relevant to folks in the construction business is the hypothetical lien defense. And that works like this. Typically, the fact scenario is subcontractor or the contractor is getting paid during the preference period, during the 3 months prior to the bankruptcy filing. So for that reason, he's not putting a lien on. He's not putting a mechanics lien on the property. Why? Because he's getting paid. There's no reason to put a lien on, even though it might have a right to put a lien. There's no point to getting a lien on the property because they're getting paid. It's no reason to do collection activity. The problem with that is that if the subcontractor or contractor had a mechanics lien in place on the property, then it would be a secured creditor. And why is that important? Because if you're a secured creditor during the preference period, you have to be paid. You're automatically paid in full. And the whole point of the preference is to avoid a situation where an unsecured creditor is paid in full, where other unsecured creditors are only getting cents on the dollar. So we're trying to level the playing field for unsecured creditors. But secured creditors are going to get paid in full. They're always going to be paid in full, either after the bankruptcy filing or before the bankruptcy filing. So there's no unfairness issue. First case I'm going to look at discusses the hypothetical lien defense is New England Radiator Works, 2012 case. Let's take a look at it. In this case, the debtor hired a contractor to install a radiator, paid the contractor during the preference period. Debtor goes bankrupt. Trustee sues the contractor for a preference as the contractor got paid within the 90-day preference period. The contractor argued that it had a hypothetical lien. It didn't file a lien because it was paid. But if there had been a hypothetical Chapter 7 case under 547b5, the contractor argued, well, I would have hypothetically filed my lien before the transfer, at the time of the transfer, and I would have been a secured creditor. The debtor argued, hey, no lien was filed, and the contractor's claim was unsecured, and they should be treated like any other unsecured creditor. In other words, the argument is by the contractor, if we're going to take a hypothetical situation, which 547b5 opens the door to, then in that hypothetical situation, let's extend that and say that hypothetically, if I hadn't been paid, I would have filed a lien. So that should be taken into account. Applicable Code Section 547b5. And what that says, except as provided subsection C in either section, the trustee may avoid any transfer of an interest of the debtor in property that enables such creditor to receive more than such creditor would receive if A, the case were a case under Chapter 7 of this title, B, the transfer had not been made, and such creditor received payment of such debt to the extent provided by the provisions of this title. So 547b5 creates a hypothetical situation, and the contractor is arguing, okay, well, if there were such a hypothetical situation, I would have been paid in full if I had not been paid, because I would have put in a mechanics lien. So let's see what happens. The court agreed, and there's a line of cases agreeing with this, so it varies from circuit to circuit. And the theory is the contractor should not be penalized because he didn't undertake collection activity during the 90-day preference period. And the policy there is you want to encourage collection activity by contractors. Here, we're giving the contractor credit for a statutory lien that he didn't file because he was paid. This is another hypothetical lien 547b5 case. In this situation, debtors operated a residential construction company. They went bankrupt, and during the preference period, they paid a subcontractor, someone who was working for them. And the issue is, after the bankruptcy, trustees sued the subcontractor for preference. Since he got paid during the preference period, and the, excuse me, the defense was, again, I had the right to put a hypothetical lien in the context of a hypothetical analysis of a hypothetical bankruptcy case. The court should take that into account and treat me as if, in the hypothetical bankruptcy case, example of 547b5, that I had filed a lien, because that's what I would have done if I had not been paid. The trustee argued that the subcontractor wouldn't have had a lien. Trustee analyzed the state law, and this happens a lot. A lot of these cases focus on the state law and whether there would be a hypothetical lien under the state law, and that's what happened here. Trustee argued that under state law, the subcontractor would not have had a hypothetical lien because he would have had to file, because the time ran from when the first invoice was issued, and that was his argument. Applicable code section again is 547b5. The court granted the arguments of the defendant and dismissed the case, finding there was not a preference. And the court followed the line of cases allowing the assertion of a hypothetical or inchoate mechanics lien, even though a lien was never actually filed. In this case, the court dismissed the trustee's arguments and simply disagreed with the trustee's interpretation of the applicable law, and found that the subcontractor did in fact have a right to place a lien, and it revolved around the court's ruling that the statute allowed for the placing of a lien, and the time to run began with the first substantial work done on the property. Another line of cases deals with the same issue because it comes up all the time. And this issue it's a similar issue. The argument is, and this happens quite a bit, is that the debtor asks for lien releases, formal lien releases, when it makes a payment during, prior to the bankruptcy case, in that 90-day preference period. And subcontractors or contractors sign the releases because they got paid. And the question is, how is this defense? How is this fact pattern amount to a defense against a preference case? And the theory that's used is that it's a contemporaneous exchange for new value. The case we'll look at is Seacoast Ready-Mix Concrete from the District of New Hampshire. In this case, the defendant was a subcontractor who supplied concrete. The debtor was a general contractor. Right before the bankruptcy case, the subcontractor supplied concrete. Debtor asked for lien releases, and the concrete supplier said, "Sure, I got paid, so I signed the releases." Of course. What's interesting about this particular case is that no notice was if the contract supplier, the subcontractor, had not been paid, no notice would have been required. He had a lien according to state law upon completion of the work and supplying the concrete. So he automatically had a lien, and he gave it up. Because why? Because he got paid. What does he need a lien for? Contractor, of course, goes bankrupt. trustee is appointed, and the poor concrete supplier, subcontractor is sued for preference. The creditor, the subcontractor, argued that it released valuable rights, and the payment that it received was an exchange for releasing the lien. It's a creative argument, and let's see if it flies. Relevant code sections 547C. The court ruled, I think rightly, that it wasn't of value because if the subcontractor had not released, if it hadn't been paid and had not released a lien, put a lien, then on the city, basically the city property, then the city would have had a claim against the debtor, and it would have cost the debtor whatever it should have paid the subcontractor. So release of lien rights can be new value, at least as ruled by this particular bankruptcy court. This case is another defense for subcontractors and contractors. It uses an entirely different theory called the Earmarking Doctrine. And this happens also a lot in construction bankruptcy cases. And the theory behind this is that unsecured creditors are not being prejudiced because what you're really having is a transfer of debt from one creditor to another creditor. And you're not really having a transfer of assets. No one's getting paid in full to the detriment of other unsecured creditors that are later not getting paid in full. And a quick example is debtor takes out a construction loan to pay specifically to pay a subcontractor. So what happens in that situation is that the subcontractor is paid, so that claim against the estate no longer exists, and that claim is merely transferred to a new creditor, the construction loan. So you have a new creditor taking over the claim. You don't really have a loss of assets, which is what the preference laws are worried about. This case discusses that theory. It's a 2009 case from Arkansas. This is an appeal to the district court. The bankruptcy court already granted the defendant's motion to dismiss the case, the creditor's motion. And what happened here happens all the time in this industry. Debtor was a home builder, creditor was a subcontractor, supplied building materials. Creditor is not getting paid, subcontractor is not getting paid. He makes a threat to file a lien, and the debtor takes out a bank loan, a construction loan, to pay the subcontractor in full, which is what happens. Home builder goes bankrupt, trustee's appointed, and sues the subcontractor, saying, hey, the subcontractor got paid during the 90-day preference period, so the transfer should be avoided and the money should be returned. The creditor argued basically that it was not only was it a secured creditor, but that the funds were earmarked from the construction loan to itself as a subcontractor. And the way it worked is that there was a bank check issued to the subcontractor by the construction lender. And the subcontractor argued, hey, this is clearly earmarking. These funds were earmarked for us. They never even went into the bankruptcy estate. And this is a classic example of earmarking, because what you have is one debt, the subcontractor's debt, being substituted for another debt, the construction loan claim against the estate. So no assets are leaving the estate. So that's what it argued on appeal. And it also, of course, argued that it had a valid secured claim at the time of the transfer. Applicable code sections 547B. Transfer of an interest of the debtor in property. So that's really what the earmarking doctrine focuses on. Was the debtor's assets transferred? Was it an interest of the debtor in property that was transferred? Or was it just one loan, one debt being substituted for another debt? The court found that for the argument for the earmarking doctrine to work, the creditor had to be a secured creditor. Otherwise, the earmarking doctrine wouldn't apply. The district court ruled that the subcontractor had an inchoate lien. It didn't perfect because it got paid, but it had an inchoate lien, and the right to perfect would continue post-petition into the bankruptcy case. And the court said that this was enough to put it in the secured creditor category, and therefore the earmarking doctrine could apply because it was one secured creditor paying another secured creditor. Another example of a defense that comes up once in a while in construction cases, in the context of preference cases, is the constructive trust defense. And this happens when you have a general contractor and he's got subcontractors and a subcontractor to the subcontractor, and obviously the general contractor sees that his subcontractor may be in financial trouble, and then starts trying to address that because the general contractor doesn't want one of the subs not to get paid, and then put a lien on the property and create liability for the general contractor. So sometimes the general contractor will cut a joint check to both the first sub and second subcontractor to avoid the possibility of the first subcontractor, because of financial difficulties, not paying the second subcontractor, and that's what happened in this case. Impulse NC, it's a 2008 case from Maryland, bankruptcy level. In this case, this was a rail construction project, and just as like I described in the previous slide, both the debtor, who eventually filed bankruptcy, and the preference defendant were both subcontractors. A general contractor issued, obviously the general contractor had some thought that the first subcontractor was in trouble, and so issued a joint check cashed by the second subcontractor. Then the first subcontractor does file a bankruptcy case, trustee is appointed, and sues the subcontractor for a preference. The second subcontractor for a preference. The creditor asserted that the fact that there was a joint check essentially created a constructive trust for the second subcontractor, and that these funds were kept separate for a reason, that the general contractor wanted the second subcontractor to get paid, and he made the payment in such a way to guarantee payment, created essentially a constructive trust for the second subcontractor. Trustee argued that at least some of these funds were commingled with other funds, and that joint checks were not eligible to be constructive trust. Applicable code sections 47B, 1, 2, or 4, the benefit of a creditor. The court found, in fact, that the joint check process did create a constructive trust, and since the subcontractor endorsed these checks immediately, there really wasn't any commingling of funds, and so that argument was out the window. And this is an important case, and this happens quite a bit. A lot of times in the construction business, you're going to have one entity in the chain of subcontractors that's in financial trouble, goes bankrupt, and arrangements like this do exist. And it's important to know that this is a defense that can be used against a trustee that later sues for a preference. that kind of sums up some of the defenses available to people that are being sued in the construction business. And these are fairly common defenses, but they're a little bit sophisticated, and it's worth knowing that they're available.